Hello, I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines, where I have workers' compensation judge Pam Laramore. She is the judge for District 5, which covers the 6 parishes, including East Baton Rouge Parish. The judge is going to talk to us about what type of benefits or claims you have when you're hurt while you're at work. Bottom line, very limited. Your medical expenses, 2/3 of your average weekly wage. She says you need a lawyer. Join us on the next Legal Lines with workers' comp judge Pam Laramore. Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines, where we're going to talk about the law and you and why it should matter to you what a law is. You know, in America, in our cities, in our states, in our federal governments, they all pass thousands, hundreds of thousands of laws, regulations every single year, and they either directly or indirectly affect you. That's why you need to know what a law is. It's an exercise of power over people, places, and things. So join us on the next Legal Lines, where knowledge is power. Hello, welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show for the very first time Judge Pamela Laramore. Judge, thank you so much for being on the show.
You're welcome.
You are a judge in a very specialized area, and that is of workers' compensation law. Before we dive into your current role as a judge for, what, 25 years in the workers' comp realm, kind of explain to folks your background, educational, and how you got into that.
I was born and raised in DeRidder, Louisiana, and then went to USL, which they have now renamed ULL, in Lafayette for my undergraduate degree. I got a poli-sci degree there, and then came over to LSU Law School in 1978. I graduated high school in 74, college in 78, and LSU in the fall of 81. I originally started out my career with Fred A. Blanche III doing bankruptcy, and then later moved out on my own. Dennis Whalen, who just recently passed, was a big mentor for me, and I was in his office, and he let me hang my shingle out there to get me started. And I practiced just a little bit of everything.
General civil practice.
Walk in the door and you need it, and I know how to do it, or I'll find out how to do it.
That's right. Got to pay the bills.
That's right. And did that for 9 years, and then lucked into this job, actually. They were in 1991 or 1990 when they separated out completely the workers' comp arena from the district court and set up a court system. They were setting up courts around the state. At that time, when I came on in 91, when I got contacted, they were working out of police jury rooms, really? Unemployment offices, in the different parts of the state. And one of the judges, the judge for Lafayette, Judge Keller, who is now our chief judge, was the Alexandria judge at that time, and she went on maternity leave, and she says that she told them she was getting ready to go, and they waited to the very last minute to do anything about it. And then
they're freaking out?
Yes. I happened to be in Judge Luce's chambers.
Which is family court.
Which was family court back then. Judge Luce has moved on now. And her secretary, they had sent out an APB to all the district court judges. We're looking for somebody to fill in for 6 weeks while this judge is on maternity leave. And her secretary looked up at me and said, "Would you be interested in something like this?" And I said, yes. I had been eking it out for 9 years, and the idea of just getting a paycheck for something sounded very good to me. And so I went back to my office and shuffled some things around, and I interviewed on Thursday, and I got the call Friday, and I was in Ellick hearing cases on Monday.
Now this was all implemented under Governor Romer's period of time in office.
Right. This is at the very beginning. This was January of 1991 when I got started.
So you've been there for, am I right, 25 years? You've been there from the beginning?
It's 24. It'll be 25 in this coming January.
So you've seen it from its infancy until where we are now today?
I have. I started out in the Alexandria area hearing trials and carrying my own court recording equipment, and had to handle the court recording equipment. I'll never forget, I'd go in, set it up in the unemployment office, and there'll be attorneys and people miling around out there, and I remember an attorney coming into the door and going, "Do you know when the judge is going to get here?" And I said, "I'll be with you in just a moment." And I'm setting up the microphones and setting up the recorder, and he said, "I just want to know how long before the judge gets here." And I said, "I'll be with you in just a moment." And when he said it a third time, I said, "Good morning."
Ruled against him, Judge.
I said, "Good morning. I'm Judge Pam Moses. Nice to meet you. I'll be with you in just a moment." And
I bet he shut up.
I said, "It's okay. I understand.
Right.
I'm young at that time, 35. I'm a young woman setting up court recording equipment. Back in 1991, people didn't necessarily think that
Right.
I was going to be the judge. But I ran ELEC for probably almost 8 months to a year, and then they hired a local judge there in Alexandria and to run that office. And then I went to Monroe and did exactly the same thing. I worked the Monroe docket until they hired local judge in Monroe. Then I went to Houma. I went to across the river, Harahan. Well, it was Harvey at the time. And every one of these places, I'm working out of little police jury offices, this kind of thing. But when they hired the local judge,
like a circuit judge.
Yeah, when they hire the local judge, they work on a permanent building, and actually doing leases and that kind of thing. And after everything was set, there was only 2 areas I did not work. Lake Charles, which would have been nice because it's closer to DeRidder and I could actually see my family because they had that one set up. And Shreveport was already set up. I went to both those places to help out from time to time.
So now we have how many districts in the workers' comp judicial system?
Well, there are 9 districts, and 2. District 1 is divided into East and West. That's Shreveport, the Shreveport, Bossier, Monroe area.
Okay.
Shreveport's D1 West, and Monroe is D1 East. And then the 2nd district is the Cenla area, and that's Alexandria. You have the Southwest district, that's District 4, that's Lake Charles and the surrounding parishes. And then you have the Lafayette district with the Lafayette parish and those in that area, and then Houma. And then you have Baton Rouge, and we cover 6 parishes in Baton Rouge: East and West Feliciana, East and West Baton Rouge, Iberville, and
Y'all have the
Capee.
largest docket, largest caseload?
We used to, but actually Lafayette
Really?
is and Lake Charles those 2 areas are booming
because
now.
of the economics going on.
It's the economics.
Building.
It's shift, and it's shift post-Katrina shift as well.
And then I guess New Orleans has an area.
New Orleans and Harahan, which is across the river. You got New Orleans proper, and then the Metairie area and Harahan, and then the North Shore. You have Covington. We have the Covington docket.
Okay. And now you have a staff, I presume, that goes ahead and does the court reporting and all the other miscellaneous tasks that you don't want to mess with?
When the districts got set up and got actually housed, having their own place, they started hiring the people to run it, secretaries, front desk clerks. We have contracts with various court reporting agencies, local court reporting agencies.
Right. We'll continue this on the next segment. This is Locke Meredith Legal Lines and my very special guest, Judge Pam Laramore, workers' comp judge. We'll be right back. Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines, where we're going to talk about you and the law. You know, a law is nothing but an exercise of power over you, people, places, or things. But where does that power come from? Where does the government get that power? And how is that power exercised? And do you play a role at all? That's what you need to know. So join us on the next Legal Lines, where knowledge is power. Welcome back to Legal Lines. I'm Locke Meredith. Very pleased to have on the show Judge Pam Laramore. She is a workers' comp judge here in the Baton Rouge, and I think it was a total of 5 surrounding parish area.
There's 6 parishes, including East Baton Rouge.
So let's explain to folks why the Romer administration, and really workers' comp law for that matter, has been kind of pulled out of the normal kind of injury tort world, civil law world. Judge?
Well, prior to the creation of the workers' compensation system, they did have a process by which, an administrative process by which you would file a dispute with the Department of Labor back at that time, and they would have somebody look at it, look at the records you sent, make a recommendation, and you could either agree or disagree and take it to district court. They decided...
Meaning here, the regular trial court.
Right, regular trial court. The parties, the insurance companies, the system in general, it was over, the district courts were getting overloaded. Workers' comp cases were supposed to be fast-tracked, and you're supposed to be able to get them through quicker because you have injured workers.
Right.
But they were getting bogged down. And so that's why they carved out just the workers' comp arena and created an actual judicial system, not just a recommendation system.
Total separate court system.
Correct. It's more akin to your family court type situation that's been carved out than it is to any other actually administrative situation, because we are the triers of fact. We make the decisions, and if you want to appeal our decision, they're taken to the First Circuit. For me, the First Circuit Court of Appeal is taken to the Court of Appeal.
And you said in the days prior, the decision of the person was a recommendation, it wasn't binding.
Correct.
These days, it's a decision that's binding, and the only relief you get if you think it's wrong is to take an appeal, just
Correct.
like you would in the regular
Correct.
trial court.
This is your trial, and it will look, feel, and is a trial.
Let's discuss, philosophically, the whole reason was that businesses wanted certainty. They were worried they were going to get sued and pay millions out for certain kinds of claims. Employees are dying. They can't pay their bills. They're concerned. So they removed the issue of fault for these kinds of cases, workers' compensation cases. Would you explain to the folks what that really means?
Well, it means that if you get injured on the job today, well, and since 1991, the employer owes a responsibility to the injured employee if they've been deemed disabled by their treating physician, 2/3 of their average weekly wage in an indemnity benefit, a wage benefit, plus pay for their medical treatment until they're able to return to work or to some form of employment. That is in exchange for no pain and suffering being awarded, and the employee getting benefits, getting treatment, and not having to go to an attorney or somebody and have them foot the bill for that and go to court.
And take months or years to get a final outcome.
Correct. And so it was a trade-off. We don't care if you cut your own finger or how you got injured, as long as if you got injured in what we call the course and scope, in the course of your job or in the scope of the job duties you do, then you get compensation, workers' compensation.
So a simple example, absurd example, would be if I'm chopping wood for my employer and I chop my own foot off, there's really nobody to blame but me. But if I did that in the course and scope of my employment, even though I'm the dummy who chopped my own foot off, my employer is going to pay me benefits because I was injured and it's prevented me to be able to return to work for a certain period of time.
That's correct. That's correct. And that's in exchange for the time when you get hurt because your employer failed to have you follow some safety rules or something, and you lose your leg. And instead of suing him for pain and suffering and penalties but pain and suffering is the biggest aspect of any injury, really, typically. Then you don't have, he gets that protection. He gets that shield. I'm your employer. I will pay for your medical, and I will pay your indemnity benefits.
Meaning your lost wages,
right.
2/3 of it.
And your wage benefits. And you don't get to sue me for pain and suffering.
But the wages that they get, so it's you don't have to prove anyone did anything wrong.
Correct.
You could have hurt your own self, and you're going to get benefits. The offset, or the negative, if you want to call it that, for the employee is, like you said, they can't sue for anything except medicals and wages. And the claim for wages is capped at a certain amount, both on the low end and on the high end. Would you explain that to folks?
Well, that's correct. Typically, you get 2/3 of your average weekly wage. The average weekly wage is determined if you're a regular full-time employee. They take the 4 weeks preceding the week of the accident. They never count the week of the accident. That's thrown out. 4 weeks preceding to get your average weekly wage. If you're a regular full-time employee, there is a presumption that you work a 40-hour week. So even if you worked less than 40 hours a week in some of those weeks, as long as it wasn't at your choice, then you get that 40-hour presumption. If you worked more, then your average weekly wage would be a little bit bigger. I mean, some of these plant workers can work a good deal of overtime. Sure.
Right.
So your average weekly wage is then calculated. Your indemnity benefit, your wage benefit, is 2/3 of that average weekly wage.
So let's use some numbers. Let's say they make $3,000 for that 4-week period of time. They're going to get $2,000 even though they made $3,000.
But there is a cap.
Right.
Every year, the department sends out the new maximum and minimum indemnity benefit. And presently, I didn't bring that number with me.
Slightly over 600?
Oh, I think it's in the 500s right now.
I was trying to find it too myself.
So
the most they can get is
I didn't bring.
Somewhere between $500 and $600 per week. So,
I mean, even if I got hurt, a plant worker that makes $3,000 gets hurt. That's the most he or she can
So
get.
in our example, if the cap is $2,000 per month in essence, and 2/3, I make $3,000, but I get 2/3, it's $2,000, I'm gonna get my $2,000. But if instead, after 2/3 represents, say, $3,000, I'm still only gonna get $2 because that's capped.
Well, you won't even get $2. You're gonna get $500
per week.
Per week. I'm
talking about per month.
Okay, I'm sorry.
Yeah,
no, if your average weekly wage is $2,000 a week, and there are people out there who make that, you will get $500. It's whatever the cap is.
Okay, we'll continue this on the next segment. This is Locke Meredith with Legal Lines. My special guest, workers' comp, Judge Pam Laramore. We'll be right back. Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines, where we're talking about the law and you. The law is nothing but an exercise of power by a government over you. But because our framers in our Constitution knew that power could be abused and corrupting, they chopped up power between the executive branch, the legislative branch, the judiciary, and you. So join us on the next Legal Lines, where knowledge is power. Welcome back to Legal Lines. I'm Locke Meredith, and again, very pleased to have on the show Pam Laramore. She is the workers' comp judge for District 5, which covers 6 parishes here in the Baton Rouge area. Judge, let's talk about really that scenario we were just talking about would be the payment of temporary total disability benefits. Sure. Explain to the folks again what's required to get that.
Sure. If you're injured and you go to the doctor and the doctor says you can't go back to work right now, we're going to take you off work. It gives you a no work slip. Take it back to your employer. They turn it into the insurance company, and the insurance company has 7 days to start your indemnity benefits, okay, your wage benefits.
Making your payments.
Right, calculated as we previously discussed.
And it's paid weekly.
Paid weekly. It's calculated weekly, but it's paid however you got paid. If you were paid bi-weekly, if you were paid weekly, it's supposed to be paid the same way you received your wages when you were working.
Okay, and those benefits can be capped because it's somewhere between $500 and $600 per week.
And it depends.
Is the most that will be paid.
Correct, and it depends on your date of accident because the cap changes each year, and your indemnity benefit cap is for the year you were injured.
At the time you were injured?
At the time you were injured, and it stays at that.
When you're injured as an employee, it's best advice to immediately notify your employer and create a written document, is it not?
Absolutely. I've seen time and time again when a big mistake is made, when, especially with regard to back injuries, somebody will pull their back lifting on something
and try and suck it up.
Sure, they've had this before, mowing the yard or whatever, it'll go away. Report it. It's very important to report it. It may go away, and that's fine. But if it develops into something bigger, it's easier for your employer to believe you that it happened at work and on the job, and not that it happened mowing the yard or something on the weekend before, if it is documented somewhere. It doesn't mean that it's impossible to prove, but it certainly makes your case much better, so that it's been documented that you complained about this.
And there is...
And as soon as you feel that it's not going away, seek medical treatment. Notify your employer you need medical treatment, and seek medical treatment. If they don't send you to somebody right away, go see somebody on your own.
And so you're going to give the notice, you're going to seek medical treatment. That doc says you're not to go back to work, you need to take off work for a while. You provide all that information as soon as you have it to your employer, and then hopefully they timely pay your benefits. And the next scenario, though, is when the party, the injured employee, is then released for work by the doctor. And if he says full speed ahead, you're not going to get any more payments. You get your job. Hopefully they haven't laid you off. They have that right, do they not?
Oh, certainly. If once you've been released to full duty, well, I mean, this is a right to work state. So your employer's never required to keep the job open for you. But but they are required through their insurance company or through the bond they posted with the department to pay for your workers' comp benefits until you receive a full duty release. If you receive a full duty release, then the benefits stop, and like you said, hopefully your job is still there for you to go back to
work, or you go
get another job.
Okay. Now the scenario develops to say, though, that the doctor says, you know, I've done everything I can do for you, but you're still on 100%. So I give you these restrictions. You can't carry a lift over greater than, say, 50 pounds or whatever, climb stairs. Now he has restrictions, can't do the same job. What benefits might he still be entitled to?
That would be supplemental earnings benefits. These restrictions would be turned in, just as before, to the employer and the insurance company. And if the employer can accommodate your restrictions, then you'll go back to work. And
might be an office inside job instead outside.
Right. Tool, or a common job has been a tool pusher.
Right.
You know, you'll help deliver tools or whatever instead of using them until you get better.
Right.
However, if the employer does not have a job for you, then they may very well, the insurance company may hire a vocational rehabilitation expert, someone to review the job market for you, help you with a resume, provide you with information on jobs within your capabilities, trying to get you back up to your pre-injury wage.
And you don't actually have to get that job. That survey just says, hey, these jobs are out there.
Well,
your doctor, a lot of times those folks will go get the okay of the doc.
The doctor needs to approve the jobs, and the injured worker needs to attempt to secure them. If the injured worker tries to secure all of these jobs and nobody will hire him, he has shifted the burden back to the employer and the insurance company to prove that these jobs were really available to him. They just, I don't know, didn't like the color of his hair or whatever. Okay. So there is the burden of proof shifts back and forth there. But let's say that they find you a job and you go and work a job as a tool pusher for somebody else.
Right.
But you're not making the money you were making before. You fill out what they call a 1020 form. You fill a form out each month, send it to the insurance company, tell them how much you earned this month, and then they calculate your supplemental earnings benefits monthly. It goes from a weekly benefit to a monthly benefit, and it's reduced by the amount of money that you're making.
So, example, let's say you were making $20 an hour before you hurt. Now you're able to make $10 an hour. You're losing $10 an hour. And they will pay supplemental earnings benefit of 90% of that amount.
Two-thirds of that amount.
Okay.
Until you reach 90% of your pre-injury wage.
Forget my own.
No, that's okay. If you reach 90% of your pre-injury wage, then that's considered
That's
good
right.
enough.
You're not entitled to the supplemental. The other attack the insurers often, the employer insurers take is, we don't necessarily believe your doctor that you're disabled, and they have rights in that regard. Could you explain to the folks what those are?
Certainly. The employer and the insurance company, they have a duty to see to it that you get medical treatment. And they have the right to their own physician. It's called a second medical opinion, an SMO for short.
And they're not necessarily there to treat them, but just to evaluate and see what their opinion is.
If the insurance company or the employer feels that the treating physician is not providing the proper treatment or asking for too much, they can have him evaluated by the SMO to see if they agree with the treating physician.
And then if you, Judge, have two contrary opinions, you can say, I want him to go see a doctor.
I certainly can. However, today, now we have medical treatment guidelines. And,
it's a whole new world, isn't it?
It is, and there's not so many SMOs being used anymore because your physician is going to fill out a form for physical therapy, an MRI, whatever treatment they want, send it to the adjuster. The adjuster will typically run it through their utilization review process. They have some doctors that just do a medical review, a records review, and let's say that they deny the treatment. Then your doctor or the attorney, if an attorney is assisting you, can send it to our medical director, the workers' compensation medical director, appeal it to him.
And then he decides.
He decides if it...
Clearly, Judge, this is an area of the law where you need a lawyer.
Yes, because doctors aren't going to follow up quite so well as an attorney.
Thank you very much. This is
You're
Locke
welcome.
Meredith, Legal Lines. My very special guest, Judge Pam Laramore, Workers' Comp Judge. Thanks for being with us.